Good afternoon to everyone. Welcome to the final rounds of the 2001 Jessup competition. This has been a fantastic week of competition. All the judges, all the teams, everything I've heard is this is just the best competition ever. So please give a round of applause for all the teams that competed throughout the week. We're also looking forward to a very exciting round this afternoon. I'm very excited and honored to have Mr. Roy Lee from the United Nations, Professor Ruth Wedgwood, an international law professor from Yale, and also Professor Jordan Paust, an international law professor from the University of Houston, to sit on the final bench. I would also like to take a few moments to introduce the two teams that will be arguing today. And please forgive me if I mispronounce anyone's names. Arguing for the applicant side, we have Team 691 from the National University of Singapore. The team includes, and if you hear your name, if you could please stand and be recognized, Kabir Singh. Stay standing. Ho Ming Chan. Sangeeta Subramaniam. And the two oralists this afternoon will be Davinia Aziz and Jason Chan. I would also like to recognize their coach, Mr. Bob Beckman. Arguing for respondent this afternoon is team number 743, Universidad Catolica, Andres Bello from Venezuela. Team members David Marquez, Courtney Dow, Daniel Camajo, and the two oralists this afternoon, Luisa Libervanche and Alejandro Franco. The two coaches are Anya Nunez and Juan Oliveria. I would also like to recognize the National Administrator of Venezuela, Elizabeth Aljuri. So good luck to both teams and have a great round.
All rise. The International Court of Justice is now in session.
Please be seated. Please proceed.
Mr. President, Your Excellencies, good afternoon. My name is Davinia Aziz, and I appear together with my co-agents, Mr. Jessup Chan, on behalf of the applicant state in this dispute, which is the Republic of Erebus. My co-agent and I will both be speaking for 21 minutes, and we have reserved 3 minutes for rebuttal. Your Excellencies, we have divided the issues as follows. I will be dealing with all the issues relating to the Alma Shoals. These include, first, the question of the boundary dispute between Erebus and Merapi, the issue of the arrest of the 6 Arabian vessels, and the relief that we seek with respect to that. My co-agent will be dealing with all the issues relating to the Grand Basin, which are first, the destruction of the Arabian deep seabed mining facility, the legality of that facility, as well as the relief that we seek with respect to those issues. So, Your Excellencies, moving then to the first issues regarding the Alma Shoals. Erebus has 2 main submissions with regards to this. First, that because of the change in course of the Krakatoa River's principal arm, there has been a consequent change in the land and maritime boundaries between the two states, thereby placing the Alma Shoals within the Caribbean Exclusive Economic Zone. Our second submission follows from this, Your Excellencies, and it is that because the Alma Shoals are within the Caribbean Exclusive Economic Zone, Merapi's arrest and detention of the 6 Caribbean vessels in that area is unlawful, and they must therefore release those vessels immediately.
I'd like a point of clarification.
Certainly, Your Excellency.
You admit that there are such things as exclusive economic zones.
Certainly, Your Excellency, yes.
You have not ratified the 1982 convention, is that correct?
That is correct, Your Excellency.
How do you take advantage of an EEZ if you haven't ratified the new treaty creating that?
The exclusive economic zone regime has entered into customary international law. This is without doubt as seen from the 1985 decision of this court in the Libya-Malta case. So if Erebus wishes to claim the rights accorded to the exclusive economic zone, Erebus must also accept the obligations thereunder. So, Your Excellencies, the exclusive economic zone concept is part of customary international law, and Erebus recognizes this. Erebus has claimed a 200 nautical mile exclusive economic zone under customary international law. Thank you, Your Excellency.
Did the court in that case dealt with the question of boundary?
Your Excellency, I believe that the question in that case was with respect to a continental shelf delimitation, but it remains that the exclusive economic zone concept is part of customary international law, and this is why I have cited the case for Your Excellencies.
How much of the concept has become customary international law?
Of course, Your Excellency, not all the provisions in Part 5 of the 1982 Convention have crystallized into customary international law. Only those provisions which have evolved into customary international law by virtue of widespread state practice are indeed part of custom, and those are the provisions that Erebus will be relying on today. So, yes, Your Excellency, not all the provisions are part of customary international law. Only some of them are, as evidenced by widespread state practice.
And all the related fishery issues, according to you, have become customary international law. Is that right?
Yes, Your Excellency, they have. If Your Excellencies would...
Let me just interject and ask you about the connection between the EEZ and your claims about the avulsion of the Krakatoa River. One of the...
Was it a vote?
Addressing Your Excellency's question first regarding the link between the two issues, Erebus's position is that the maritime boundary necessarily follows from the land boundary. This is consistent with this court's position in almost every maritime delimitation case, which is the land dominates the sea. Therefore, without a land boundary, one cannot have a maritime boundary. Now, addressing Your Excellency's question as to whether this is avulsion, Erebus's position is that no, this is not avulsion for two main reasons. First, that this should be recognized as a change brought about by accretion because of the gradual nature of the change. Second, because this is not a case in which the avulsion principle would apply, because the cases in which the avulsion principle has applied in the past, taking, for example, the leading 1911 Chamizal arbitration, first of all, Your Excellencies, the prevailing practice is that where avulsion has been held to have taken place, the parties have provided for it in the bilateral boundary treaty. And second of all, Your Excellencies, the reasonable expectations of those using the land around the river would not be affected. In the Chamizal arbitration, a business district, Your Excellencies, would have been affected by a boundary change. Here,
Why was this not a sudden change? Why do you say it's a slow change?
Your Excellencies,
Didn't this occur within a few years?
Yes, Your Excellency, it occurred within over 4 years, Your Excellency. So it is a gradual change. It is not a sudden, forcible change brought about by an act of nature within Professor Brownlee's definition.
After an 80 or 90-year quiescent period, I take it. The river did suddenly change.
Yes, Your Excellency, that is true, but the hurricanes took place over several years, 4 years to be precise, and there was not one, but 3 hurricanes, Your Excellency. So it is not at all clear that this is a movement of an evulsive nature.
You say not an act of nature. What was the act that changed the river? What caused the change?
I'm sorry, Your Excellency, I did not make myself clear. What I meant to say was that it was not a sudden act of nature. Yes, these were natural forces, they were hurricanes, but there was a series of hurricanes over several years, Your Excellency. So it is not clear at all that the avulsion principle should apply in this case, and it is also Erebus's position that the avulsion principle should not apply because this is not the factual matrix in which the principle has been held to apply in previous cases. The respondent state, Your Excellencies, have argued in their written pleadings that this is a simple case of avulsion. Erebus's position is that it is not, because in cases such as the Chamizal arbitration, the areas that would have been affected by the boundary change were areas in which there were important economic activities, there were settlements in the area. In the Chamizal arbitration, it was the business district. And in this case, Your Excellencies, what we have is a delta area that is uninhabited, does not support any important economic activities, and to which neither state has enacted any administrative or regulatory regime.
Well, let me go back to my first point, though, if I may finish it, which is the connection between the EEZ and the location of the river. Yes. Whatever might be the regime, if when we're simply speaking of the river and land territory by itself, if you're connecting the base point of the EEZ, if you like, to the mouth of the river, yes, and if the purpose of an EEZ, an exclusive economic zone, is in part to allow the coastal country to enjoy the economic fruits of the sea, which might include building platforms, if you have a regime, if you have a boundary on the river, which might change north or south, depending on the direction of accretion even, then you're not going to have any stability in the boundaries of the EEZ. And that will, in turn, deter private investment in the EEZ. Doesn't there have to be a deep stability in the EEZ to fulfill its customary law or Law of the Sea Convention purpose? So the idea that you have to necessarily change the EEZ simply because the river mouth has changed its egress doesn't make sense.
Indeed, Your Excellency is correct. Erebus's position is that if the exclusive economic zone boundary had been delimited by both parties by agreement, according to customary international law, such a situation would not arise. Indeed, we would not be before this court today on the issue of the exclusive economic zone boundary if there was a boundary agreement between both parties. But, Your Excellency, neither party has actually... Yes.
15 years from now, if, to the detriment of your country, the river should move back north, we would then draw a new EEZ boundary line.
If, Your Excellency, there was an agreement between both parties as to the exact delimitation of the exclusive economic zone boundary, then no, Your Excellency, we would not be before this court again on the issue of who the Alma Shoals belong to in terms of the exclusive economic zone.
But is our decree interim or final? What happens if the river moves north 15 years from now? Can Marapi come back and ask for a new delimitation?
No, Your Excellency, because Your Excellency's determination would be final. If Your Excellency's determined that the Alma Shoals lie within the Arabian exclusive economic zone and a final settlement is reached pertaining that issue, Your Excellency, then no, we would not be before this court.
But just help me with the logic. If, in fact, the EEZ should be connected to the river mouth, and in this case move south as you wish, why should it not move north when the shoe is on the other foot?
Yes, Your Excellency, the exclusive economic zone boundary would indeed be delimited from the new river mouth as it is today. But with the question of the land boundary and...
I mean, we have the power to change an agreement between two states? Are you going to obviate the agreement based on a decision of this court? Doesn't the agreement continue? And isn't the agreement hinged upon a boundary concerning the middle of the river or the river bed, the mouth of the river?
Your Excellency, yes, the agreement between both parties was that the land border should be at the midpoint of the Krakatoa River.
But wouldn't this agreement continue after the decision of this court?
Yes, Your Excellency, it would. But as to the question of the exclusive economic zone boundary, if Your Excellencies decide that it is the new river mouth which delimits the boundary and reach a final settlement regarding that, then the exclusive economic zone boundary would not change, even if the river were to change again, because, Your Excellencies, Erebus's position is that as long as the exclusive economic zone boundary has been decided, then it will remain the same.
On another matter, if I can
Certainly, Your Excellency.
ask a different question, aren't the principles of avulsion and accretion principles of customary law or general principles of law? Wouldn't they still be applicable if we make a decision one way or the other today?
Certainly.
Back to Justice Wedgwood's question.
Certainly, Your Excellency, they would. Erebus accepts that these are principles of custom, but Erebus's position is that they do not, the principle of avulsion does not apply here, because this is not a situation in which the avulsion principle has been held to apply in previous cases. If indeed, Your Excellencies, if Your Excellencies held that the boundary is indeed the river, which is Erebus's position, Your Excellencies, then if the boundary were to change and affect rights and interests of people using the area, then the avulsion principle would apply, because, yes.
We would like you to move on to other issues.
Certainly, Your
Have you fully responded to Judge Paust's question?
It's okay, please proceed.
Certainly, Your Excellencies. If Your Excellencies do indeed accept that the land and maritime boundaries between Erebus and Merapi have changed, this is because of Erebus's position that when the parties came together in 1947, they chose an objectively identifiable boundary, this being the river boundary, Your Excellencies, for the purposes of both parties to have shared use of that river. This is why Erebus's position is as such, and why the land boundary should be delimited by the river, and the maritime boundary should be delimited from the new river mouth, thereby, yes, Your Excellency.
In 1947, when the agreement was signed, the concept of EEZ did not exist. So the maritime boundary at that time really referred to, at best, the territorial sea. So how do you think the court should find a basis to accept your argument?
Indeed, Your Excellency is correct in pointing out that at the time that the treaty was concluded, the concept of the exclusive economic zone had not yet come into existence. The concept only came into existence at best in the 1970s or early 80s. And Erebus agrees that the effect of the 1947 treaty could only have been to delimit at best the 3 nautical mile territorial sea. Your Excellencies, Erebus's position is not, as Merapi would have it, that the exclusive economic zone boundary was delimited by the 1947 treaty.
So what is the width of territorial sea for you?
Currently, Your Excellency, the width of the territorial sea is 12 nautical miles.
And that's customary international law?
Yes, Your Excellency, it is.
Not based on the 1982 convention?
Your Excellency, I believe the 1958 convention sets forth that the territorial sea is to be 12 nautical miles, to which both parties...
Could you repeat that?
I'm sorry, Your Excellency?
Could you repeat that?
If Your Excellencies give me a moment.
That's all right, we'll move on.
Oh, thank you, Your Excellency.
Let me ask you a question about the river again. One of the arguments you make in your submission is that if the mouth of the river were not taken to be the boundary, then the state of Erebus would lack access to navigation, free navigation.
Yes, Your Excellency.
And that you just need the right to get into your inland waters, go upstream to the rest of your territory by having access to the mouth of the river. Why can't we accommodate that by simply holding that in these circumstances, a kind of equity intralegum, not ex aquo et bono, but intralegum, permits us to give your country an easement or a right of free navigation up the river, even though the land boundary will be kept as it was to the north of the river?
Your Excellency, that might...
Let's say a customs privilege, so you don't have to worry about the administrative irksomeness of your adversary.
Indeed, Your Excellency, that might be a possible solution. But in doing so, Your Excellencies, this court would undermine the very purpose of why in 1947 both states chose this river as the boundary. Your Excellencies, weighing the equities in this situation, as well as having regard to what the parties chose, we can see that if this court were not to recognize the new boundary, both states would lose first those navigation rights, the use of that river, which both states envisioned they would be able to use in 1947 by choosing that river. Secondly, Your Excellency.
Well, we will ask your adversary whether they're willing to concede the right of free navigation, so we can tie up your loose ends right here.
Your Excellency, even with a right to free navigation along the river, both parties would lose the objectively identifiable boundary that they both chose in 1947. Your Excellencies, what the parties chose in 1947 was not a line on a map. They chose a practical boundary, one with practical effect, so that people using the area could see where one state's territory ended.
You could put up boundary markers. Any geologist could examine the sedimentary rock and figure out where the boundary was. And if we draw the boundary south, then Merapi, which is a very poor country, will lose all their access to the fertile delta land for farming.
Indeed, Your Excellency, the delta would indeed be apportioned differently than it was in 1947. But it does remain that when the parties in 1947 came together and chose this boundary, they implicitly acknowledged, Your Excellencies, that both states would have shared use of this river. This is evident in the analysis of state practice in this regard by eminent publicists such as Adami, Hyde, Jones, and Boucher. So, Your Excellencies, the Delta area has not been administered by either party. There is no legislative or regulatory regime over the area. There are no important economic activities there. And, Your Excellencies, with regard to offshore resources and tying in as well the question of the existence of the exclusive economic zone in 1947, neither party had regard to the offshore resources in making this treaty. What they did have regard to was the use of that river and its use as an objective.
Let me ask you a question about distributional justice.
Certainly, Your Excellency.
I realize that your country has not thought fit to ratify the 1982 Law of the Sea Convention, a thoughtless act, almost like the American Act of Non-Ratification. But
yes, Your Excellency.
It's true that at least in some portions of the 1982 Law of the Sea Convention, the bulk of the world community has been interested in the particular plight of poor nations, and in particular the duty to allow other nations to fish the unused portion of a permissible catch.
Certainly.
Is a duty that does not apply to poor nations. So we can read into the 1982 Law of the Sea Convention some particular empathy for the plight of poor nations. So you're about to take away a very large portion of Merapi's livelihood. Doesn't that enter into a concept of equity inter legem? We would not be free to make up a principle of distributional justice, but we draw it from the 1982 Law of the Sea Convention.
Your Excellency, the question of distributive justice does work in Erebus's favor, even if the Alma Shoals were to be within the exclusive economic zone of Erebus. Because if we delimit using the Gulf of Maine 1984 decision of this chamber of this court principle, which is indeed applying equitable principles, taking into account all relevant circumstances so as to reach an equitable result, then, Your Excellencies, drawing a line from the New River mouth, which is the main geographical criterion to be taken into account according to this court, then, Your Excellencies, even if the Alma Shoals were within the exclusive economic zone of Erebus, Article 62.3 of the 1982 Convention does indeed require Erebus to give the surplus of the allowable catch to Merapi as a developing state in the region.
And although you haven't signed the 82 Convention, but you concede that as a customary law, do you?
Yes, Your Excellency, we do.
If this was your exclusive economic zone, would you be able to use military force to police that zone?
If this were our exclusive economic zone, Your Excellency, Article 73.1 of the 1982 Convention, which we accept as customary international law, would allow us to do so pursuant to laws and regulations that we have enacted over that exclusive economic zone. And Your Excellencies, this leads me, yes.
If in reverse we decide that this is not your EEZ, but the respondents, will you admit that they have the right to use military force to police that zone?
No, Your Excellency, they do not. Indeed, Article 73 would prima facie give Merapi the right to police powers, but, Your Excellencies, this is pursuant to laws and regulations that they have enacted over the area. Your Excellencies, they have arrested our vessels for trespass. This implies some sort of territorial sovereignty over the area and would lend further, would make it a reasonable inference that they do not have the requisite laws and regulations for which they can arrest vessels in their exclusive economic zone. So therefore, Your Excellencies, the arrest is unlawful even if Your Excellencies decide that the Alma Shoals lie within the Merapin exclusive economic zone. So Your Excellencies, the answer to your question is no, we would not accept that the arrest is lawful.
Since we asked you a lot of questions, we'll give you a few more minutes on the other points that you have not covered so far. You have 3 minutes. Do you have other points that you want to cover?
Your Excellency, I wish to cover just one more main point, that if Your Excellencies decide that the Alma Shoals are within the Arabian Exclusive Economic Zone, then we would not have to pay the compensation requested by Merapi. Even if Your Excellencies decide that they are indeed, that the shoals are indeed within the Merapin Exclusive Economic Zone, Merapi is nevertheless under a duty to mitigate its losses as accepted by this court in the 1997 Gabčíkovo-Nagimaros case. Your Excellencies, if Your Excellencies have no further questions.
Thank you.
Thank you.
Good afternoon, Your Excellencies. My name is Jason Chan, and as indicated by my co-agent, I am here to deal with the legal issues arising from Operation Sea Storm and Merapi's involvement therein. Your Excellencies, in defiance of its obligations under international law, Merapi has supported an operation designed expressly to destroy our facility with explosives, leaving 6 of our scientists dead and over $1 billion in damages.
Did Merapi, do we know that Merapi agreed to such an operation?
Yes, Your Excellency. Paragraph 18 of the compromise establishes that Merapi provided $100,000 for the operation, and Correction 3 to the compromise establishes that that operation refers to Operation Sea Storm, which the statement of the Aqua Protectors at their press conference confirmed was an operation to disable the facility using explosives. So yes.
It's your position they gave the money not just to this environmental group, but for that specific operation?
Yes, Your Excellency. Pursuant to Correction 3 of the compromise, that is our position indeed.
I'm confused, though. In paragraph 18, it simply says that a report appeared in the Merapi Times saying that the Merapan government provided $100,000 to the Aquin Protectors. But that's a newspaper report. Can we make a finding of fact or rely upon a newspaper report?
Your Excellency, perhaps not on the newspaper report alone, but it must also be noted that a high-level government official confirmed that report, and it was subsequently also confirmed by Merapi's internal legislative oversight hearings. So therefore, Your Excellencies, it stands as good authority that Merapi's government did indeed provide $100,000 expressly for this operation. Your Excellencies, proceeding on that fact, Airbus's position is that Merapi has breached international law in 2 distinct ways. First, they have breached their customary obligation not to support terrorists. Second, they have breached their obligation under the United Nations Charter not to use force against Airbus.
Now, we're talking about Article 2, Paragraph 4 of the UN Charter?
Yes, Your Excellency, we are.
That's the state's obligation.
Yes, Your Excellency.
But these were private activities? Are private entities subject to Article 2, Paragraph 4 of the Charter?
No, Your Excellency, they are not. If I may clarify Airbus's position before this court, we are not seeking to argue that the aqua protectors are the agents of Merapi. We are not seeking to directly impute the act of the aqua protectors onto Merapi. We recognize that this court, in the Nicaragua case, established a very high threshold of effective control before which such attributability can be found. Our position in this matter, Your Excellencies, is that it is the acts and omissions of the Merapian government itself in relation to its funding of this operation.
But isn't that exactly what was decided, that mere funding of an operation is not the engagement in an attack by the state?
Yes, Your Excellency, that was recognized in paragraph 228 of this court's decision in the Nicaragua case. However, Your Excellency, this is not a case where we have mere funding, which was what the statement there referred to. We have the funding expressly for the attack. We also have knowledge of the attack and subsequent concealment.
So you're arguing this really strictly on Corfu Channel grounds?
No, Your Excellency. Although Corfu Channel did establish the obligation to warn, our argument is that the totality of Merapi's conduct, which includes funding, knowledge, concealment, now offering safe haven to these individuals responsible, and the statements made in public in supporting the actions.
Let me ask you two particular questions. There was a new UN convention on the financing of terrorism that was supported by the French, by the British, and many other countries. It only applies to non-state actors.
Yes, Your Excellency, that is true. With regards to the financing convention, however, Erebus's position on the status of that convention is that while we acknowledge that neither Erebus nor Merapi has binding treaty obligations under that convention provides an extremely good ground by which we can determine whether or not Operation Sea Storm is a terrorist act. For example,
it's a brand new treaty. Neither of you have ratified it. Why is that even relevant to this discussion?
Your Excellency, it is relevant because, as acknowledged by agents for Merapi in their written submissions as well, the international community determines what constitutes a terrorist act by seeing what constitutes an offense under one of these counter-terrorist conventions. The latest one is indeed the Convention for the Suppression of Terrorist Bombings, which in its annex lists the 1998 convention, the Convention for the Suppression of Financing of Terrorism, which in its annex lists the 1998 Convention for the Suppression of Terrorist Bombings.
I guess my concern is the following, that the fact that the UN community limited the scope of the financing of terrorism convention to non-state actors, even though some countries such as India were interested in having state actors included in many of these terrorism conventions, shows there was not yet a consensus that government financing should fall under the same opprobrium. Let me also ask you about the Tadic case, if I could. I don't know if you're familiar with the work of the International Criminal Tribunal for the former Yugoslavia.
I will do my best to assist, Your Excellency.
But I'm wondering whether that changes the standard of control in the Nicaragua case, whether you're asking us as judges of the International Court of Justice to reconsider our Nicaragua opinion in light of the Tadic case.
No, Your Excellency, we are not asking this court to reconsider Nicaragua, as that case was in fact concerned with a body established by the Security Council, the International Criminal Tribunal for Yugoslavia. Our position is that this court is obviously not bound by the standards set in that case. We rely on Nicaragua, we accept the test for
Tadic may actually help you, so you...
Yes, Your Excellency, we recognize that. But we are faced with a particular problem here, Your Excellencies, as recognized in the Corfu Channel case. By reason of the exclusive control of a state like Merapi, for example, over activities within its internal jurisdiction and territory, the victim of a breach, Erebus in this case, is often unable to furnish direct proof of the facts giving rise to state responsibility. Here, Your Excellencies, we do not, like this court had in those instances, have recourse to, for example, what exactly was published by the government of Merapi with relation to the aqua protectors.
Nicaragua said that simple financing is not sufficient. U.S. financing of the Contras was not sufficient. So the key factor that takes it over the edge in your mind is the knowledge and the concealment afterwards.
Yes, Your
Excellency. Nicaragua said unless they're exercising effective control of particular operations, which you're not saying the Merapi government had here.
And you say there's not a direct responsibility. I'm not sure what your conclusion is. Was this an attack by the respondent, or was this a private attack for which the respondent is somehow responsible?
Your Excellencies.
You said Article 2, Paragraph 4 has been violated. and that is violated by a state.
Your Excellencies, our position is that this is a terrorist act. A state's involvement in a terrorist act is indeed a breach of its customary
Any
obligation.
involvement?
Your Excellency, if I may refer to the 1970 Friendly Relations Declaration, the obligation is stated that every state is under a duty to refrain from assisting, and other obligations are established there, for example, organizing, in terrorist acts in another state or acquiescing.
Is that provision in your memorial that you're reading from, is that with reference to Article 2, Paragraph 4, or some other article in the Charter?
Your Excellency, when this court accepted this paragraph, for example, as reflective of customary law in paragraph 188 of its decision in the Nicaragua case, it was referring to an indirect use of force in that case. Your Excellencies, this equally therefore applies to demonstrate that states cannot fund terrorists to do indirectly what they are prohibited from doing directly.
Why is this terrorism, by the way?
Your Excellencies, Your Excellency, as established, there are three elements to Operation Sea Storm which classifies it as a terrorist act under international law. First, it is the intentional use of explosives. Second, it is directed towards a state facility. And third, with the intention of causing massive damage to
What
the...
What's your
NATO-
legal authority for that?
Your Excellency, the authority for this is that these three elements makes it fall four square within Article 2.1b of the International Convention for the Suppression of Terrorist Bombings, recognized in the Annex of the International Convention for the Financing of Terrorism as one of the various counter-terrorist conventions establishing what is a terrorist act. It was also a...
Now, that's a new treaty also, and why is that relevant with respect to states that have not ratified it? But I think your definition might be a bit broad. I'm not sure that NATO bombings, for example, of government facilities in Yugoslavia wouldn't meet your test.
Your Excellency, in that case, it will be very different because, for example, terrorism often incorporates the element of private action, which we also have here. So therefore, Your Excellency, recognizing that states have actually argued that an overly comprehensive definition of terrorism would include too many different and obviously contradictory situations, it is not disputed by either party before this court that the counter-terrorist conventions, of which this one, admittedly new, is a new counter-terrorist convention, establish what are terrorist acts. So therefore,
How can it establish it if it's a new treaty?
Your Excellency, on one hand, it was acknowledged without dissent by the General Assembly in 1997, December, Your Excellency, where the General Assembly passed this resolution. So therefore, we do not argue that establishing binding treaty obligations is the effect of this treaty.
Is the General Assembly a super legislature?
Certainly not, Your Excellency, it is not. It follows, though, as enunciated, for example, in the jurisprudence of this court, that where there is such unanimous support of a General Assembly resolution, as well as support, for example, the approach taken in certain General Assembly resolutions which are repeated, this can become, for example, a rule binding on states. So therefore, Your Excellencies...
Why can it become a rule binding on states? That's what I'm trying to get to. What kind of international law is this?
Your Excellency, what we find binding here is the obligation not to support terrorists. What we find in the counter-terrorist conventions that I have, the convention which I have cited, is a definition for what constitutes terrorism.
But this is a very simple general question. How can a new treaty sanctified by a unanimous General Assembly resolution, when the General Assembly is not a super legislature, become binding international law on non-signatories? It's a very general, simple question.
Your Excellency, it does not become binding in that way. It merely establishes a grounds by which this court can determine that Operation Sea Storm, its use of explosives to destroy the facility, as well as in the process, of course, causing the death of 6 people, is a terrorist act.
Now, let me go back to the question of self-defense, though. It is the case that the president of the Security Council issued a statement which said that the Security Council as a whole had found that the construction of the polluting underwater seabed mining facility was a threat to international peace and security. Now, I realize there's a slight verbal difference between Article 39 of the UN Charter, which speaks of threats to international peace and security, and Article 51 on self-defense, which speaks about the problem of armed attacks, or agression armée in the French. But doesn't that seem cutting hairs? Here you have an act which your state engaged in, which the Security Council itself found to be destabilizing to international peace and security. Doesn't Article 51 have some greater latitude so that even if Merapi was responsible for the counterattack, it has a right to defend itself?
Your Excellency, our position is that whatever Erebus's status in terms of the Security Council presidential statement is, it does not authorize them to fund this attack against our facility because it is disproportionate, unnecessary, and taken in the absence of an armed attack.
Well, they didn't know that the poor scientists would be there. So that's what we Americans call incidental damage.
Yes, Your Excellency, it is indeed open for inference to this court that it was incidental damage, but it must be remembered that the operation was nevertheless funded by Merapi specifically to blow up the facility. And yes, the 6 deaths are relevant before this court.
But that was a measure of self-defense, because you had disregarded a clear Security Council directive to cease and desist your activities. You said you didn't care what a mere recommendation, in your words, from the Council might be. So if you won't listen to words, you had to listen to reports.
And I'm still troubled why a vote in the General Assembly can be more authoritative than a decision, quote unquote, of the Security Council.
Your Excellencies, Erebus's position on the Security Council presidential statement can be summarized as follows. Yes, Your Excellencies, as recognized in the compromis, we considered it a recommendation, and Your Excellency, if I may draw this court's attention to paragraph 12 of the compromis, it was not established that the mining facility was a threat to international peace and security. The text of the compromis reads that the Council determines that the boundary dispute and potential environmental catastrophe constitute a threat to international peace and security. So therefore, Your Excellencies...
Wasn't there a boundary dispute?
Yes, Your Excellency.
And what did this decision of the Security Council require you to do?
Your Excellency, they demanded that the operation not be started up until it was proved to their satisfaction.
Did you follow that?
At that time, Your Excellency, our position was that we were entitled to not follow it if necessary, but at this point of time, Your Excellency, there has been no breach of that request because the operation has indeed not been brought online. Furthermore, Your Excellencies...
Aren't you bound by decisions of the Security Council under the UN Charter, Articles 25 and
yes, Your Excellency.
48?
Yes, Your Excellency. We are indeed bound by the decisions of the Charter, but as the language of Article 39 makes clear, even acting under Chapter 7, the Council may issue both recommendations and decisions. A decision of this sort, Your Excellencies, is a non-procedural matter for which Article 27 applies, which must...
There's been a great deal of innovation, though, over the years in the way the UN Charter is applied to make it a working instrument. For example, we don't have Article 43 troops, you just have countries that act upon the recommendation of the Security Council. You don't have, we count abstentions as concurrences when we're deciding whether a resolution has passed by an adequate vote. So here you have the president, who is, I take it, a venerable person, reporting that the council has determined, which is like deciding, that the boundary dispute is a threat to peace and security under Chapter 7. And if you look at Article 25, it speaks of decision and Chapter 7. So isn't every requirement fulfilled?
Your Excellency, Erebus's position on this matter is that notwithstanding the change in the Security Council's procedural matters so far, nevertheless, decisions which are binding under Article 25 on non-procedural matters must be taken by an affirmative vote of 9 members of the Security Council, reflecting the concurring votes of 5 permanent members.
Simply for the sake of argument, that this did count as the equivalent of a Chapter 7 resolution voted straight up by a vote of at least 9 out of 15. In that case, would not the state of Merapi be entitled to hire somebody, if need be, a mercenary group like Executive Outcomes or Executive Action, to, in fact, undertake the act of self-defense that it was not itself able to carry out?
Your Excellency, Erebus's position on that is no, they are not entitled to do so. Doing so, as they have done in this case, where they have essentially hired the aqua protectors, is unnecessary, disproportionate, and Article 51 has been recognized by this court in both its nuclear weapons advisory as well as the Nicaragua case to require an armed attack first. Here, Your Excellencies, Merapi holds up...
What about the language in the Charter concerning the inherent right of states to engage in self-defense? In the Caroline case?
Your Excellency, the Caroline case, in fact, established a very high standard for necessity and proportionality, even though it did not mention the armed attack. Even, Your Excellencies, if we take Merapi's written position that self-defense can be exercised in the absence of an armed attack, it must nevertheless fulfill the conditions of necessity and proportionality.
So you're making a use in bello argument, not a use ad bellum argument.
Yes, Your Excellency. In this case, though, both conditions are not fulfilled, and therefore the unlawfulness of their support of this terrorist act is not excused.
It would only be necessary, if I may put words into your mouth, a necessary use of force when the actual catastrophe had occurred.
No, Your Excellency, not in those terms. For example, in the damage which might have occurred, which has not been proven, Your Excellencies, of the mining facility would have taken a long time to develop. It is 300 nautical miles away from the area in question, and furthermore, it has been thoroughly tested by the Arabian competent national authorities. Now, Your Excellency...
But if the Council had passed such a resolution making their own finding that there was a, to use their words, a potential
Threat.
Environmental catastrophe, would not their finding preclude your own personal view of the matter?
Not necessarily, Your Excellency. For example, Principle 15 of the Rio Declaration places the assessment of environmental impact assessments at the hands of competent national authorities. So therefore, while this court is certainly free to take into account...
When the Council acts, they're finding... We've had the problem of the relationship between the Council and this court in the Lockerbie case. But in general, we try to have a convergent, consistent approach. And if the Council itself makes a finding of catastrophe, we can't go behind that and re-examine it. Aren't they competent to make findings of fact for purposes of authorizing the use of force?
Proceeding on that hypothetical, Your Excellency, certainly they are. And in that case, perhaps the necessity requirement would therefore be different from the necessity that was argued in the Gapchikovo-Negi. Your Excellency, I see my time is up. If I could summarize my argument on Your Excellency's questions on self-defense.
Yes, please.
Thank you, Your Excellency. Your Excellencies, this is a case, if Your Excellency therefore disregards the long-term and uncertain nature of the environmental damage here, which was the foundation as to why the court in Gapchikovo-Negi did not find necessity in paragraph 55 of its judgment. Nevertheless, Merapi is under an obligation as recognized in Article 2.3 of the Charter and accepted as customary in paragraph 291 of this court's decision in the Nicaragua case to settle this dispute peacefully. Your Excellencies, even if we take into account the necessity requirement, this has been disproportionate. Article 33 of the United Nations Charter provides a variety of means by which Merapi could have settled this matter. Arbitration, mediation, negotiation are just a few of the measures which are brought to mind there. It is the same reasoning that the court provided against Hungary in the Gapchikovo-Negi case, as well in paragraph 56 of its judgment. So therefore, Your Excellencies, this has not been a valid exercise of the right of self-defense.
You said, though, if I may just, with the President's permission, ask you one more question. You said in your note to Merapi that any delay in commencing the operation is unacceptable. So you did not offer to suspend operation pending negotiation.
Yes, Your Excellency. And while I have no instructions from my government with regard to their statements to the Security Council, it must also be borne in mind that it could be because Erebus felt that Merapi did not feel a need for it since it had known of the mining operation for many months, Your Excellencies, but made no protest. So that could be a reason as to why the statement was made. And Your Excellencies, if Merapi had an objection to it, it should have brought the objection to us peacefully and not funded a unilateral operation by private individuals to bomb the facility.
Before you go, just one question. Can you give us a very, quickly your view? What kind of confidence that this court can have with respect to the Security Council's actions?
Your Excellency, that is indeed a very controversial question given this court's position which it took in the Lockerbie case. It did not, in the judgment of that case, make clear whether it was willing to exercise supervisory jurisdiction over the Security Council because, as can be seen in the 1996 order, it simply stated that the resolutions passed after the filing of the motion were not to be judged on by the court. However, Your Excellency, His Excellency Christopher Weeramantree, in his dissent to that case, suggested very strongly that this court does not indeed exercise supervisory jurisdiction over United Nations Security Council resolutions, but, Your Excellencies, this court is competent to hear the same matter. Neither party asks for a determination of the legality of the resolution, or in this case, the presidential statement, and therefore, Your Excellency, this court's jurisdiction is not in any way impugned.
Thank you.
Thank you, Your Excellency.
May it please this honorable court. Good afternoon, Your Excellencies. My name is Luisa Teresa Lepervanche, and I am an agent on behalf of the Kingdom of Merapi. My co-agent is Alejandro Enrique Franco, and sitting as counsel is Daniel Camejo. I will be addressing this court for the next 22 minutes regarding the following two issues. First, that Merapi has the right to exclude persons and vessels of Arabian nationality from fishing the Alma Shoals. And second, that the Arabian seabed mining operation is in breach of the legal regime which governs activities on the seabed of the high seas. My co-agent shall be addressing the court for the remaining 20 minutes regarding the following three issues. First, that the Arabian seabed mining operation is in breach of international environmental law. Second, that Merapi is not responsible for the attack against the mining facility. And third, that Merapi is under no obligation to surrender the members of the aqua protectors responsible for the attack. Your Excellencies, Merapi shall be saving 3 minutes for Sir rebuttal. And if it pleases the court, I shall begin with the first issue.
Please do.
Your Excellencies, our first submission is that Merapi has the right to exclude persons and vessels of Arabian nationality from fishing the Alma Shoals, notwithstanding the change in course of the principal arm of the Krakatoa River. Your Excellencies, it is Merapi's contention that the frontier remains where it has been for the last 53 years, and that is so because of three reasons. First, because of the interpretation of the Treaty of Amity and Peace. Second, because of the principle of stability of frontiers. And third, because of the rule of avulsion. With respect to our first...
Now, we heard counsel on the other side that this avulsion doesn't apply because this wasn't sudden.
In the treaty, Your Excellency? That it was a sudden...
Counsel from the other side said
yes.
This was not a sudden shift in the river. Do you
that
agree?
Was not sudden.
Why
well,
do you
it is
disagree?
our contention that it was sudden, Your Excellencies, because of the fact that the river shifted at least 50 nautical miles, the length of the Alma Shoals, as is evidenced by Annex A of the Compromis. And, Your Excellencies, it shifted in a short period of 4 years, which means that it shifted 19 kilometers in 4 years. If we make a rough conversion, Your Excellencies, or if we if we determine how many meters that meant a day, it means that the river shifted 62 meters a day, approximately 2.5.
Is there any test in the established case law?
Excuse me, Your Excellency?
Is there any established test in our precedent for the length of time and the degree of movement that constitutes avulsion versus...
Yes, Your Excellency. With respect to accretion, there have been several cases of the United States Supreme Court. For example, we would like to cite the case of Louisiana versus Mississippi. In that case, Your Excellencies, the Mississippi River shifted in a period of 90 years, since 1823 to 1913. And, Your Excellencies, it shifted 6 miles. That was considered accretion. In this case, we have a shift of 90 kilometers in 4 years. It is our contention that the suddenness of the change is evident by the fact that it could be perceptible, that a river that is shifting 2.5 meters per hour is definitely a shift that is perceptible. And for that reason, Your Excellency...
How would you interpret your treaty when your treaty talks about a boundary existing along, is it the channel of the river or mouth of the river, from the mouth of the river?
Your Excellency, it also...
And now we have a new mouth of the river. How does this principle of avulsion, how does this concept relate to treaty interpretation?
Well, first of all, Your Excellency, we would like to answer the question in 2 steps. It refers to the mouth of the river, but it also makes reference to Cape of Rialto and Pigeon Rock in the same clause. And therefore, it is absolutely clear that what the parties intended was not exclusively the flow of the river to constitute the boundary, but also that it was the location of the river at that time between Pigeon Rock, Your Excellencies, and Cape of Rialto, because this was a negotiation that took years.
You're not arguing, though, that if the change had happened much more slowly, but inexorably, so that over the last 50 years or 30 years, you had accretion upon accretion upon accretion, then what?
If we had accretion upon accretion upon accretion, Your Excellency, I'm on, with respect to the interpretation of the treaty.
Yes. Well, I guess what I'm wondering is, the 47 treaty speaks of these 2 landmarks
Yes.
that bracket
Yes.
the mouth of the river. It's still perfectly conceivable that the river would have shifted over a longer period of time and exceeded one of those landmarks.
Well, Your Excellency, it is our contention that the parties could have foreseen, yes, that the river could shift under the because it had shifted in 1901. However, they must have, that if the treaty did not provide for the shifting of the river, what would happen in the case of the shifting of the river? Then we have to have recourse to international law. And having recourse to international law, we have 2 principles. The principle of avulsion, the rule of avulsion and accretion, which we have already submitted, and the principle of stability of frontiers, which...
You mean customary international law, I guess. When you say principles of international law, you mean customary international law?
Well, Your Excellency, we would submit that the rule of accretion and avulsion could be deemed both customary international law and a principle of law, because this rule is recognized by legislations of a general principle of law under Article 38, Paragraph 1, subsection C, which would be binding. It is our contention that this particular rule is contained in several legislations, both of common and civil law, and actually it has its origin in Roman law and was codified first in the 1804 Napoleonic Code. So
let me just explore with you for a moment what I'm getting at, which is that if the changes had taken place by accretion,
yes,
slowly over a period of time, even though they had exceeded 90 kilometers, you would concede that at that point the boundary would change?
No, Your Excellency, because our avulsion accretion submission is an alternative to the first 2, the interpretation of the Treaty of Amity and Peace and the principle of stability of frontiers. So our first submission is that the interpretation in itself, either by plain treaty reading of the treaty under Article 31.1 or by having recourse to supplementary means of interpretation under Article 32 of the Vienna Convention, would lead to the conclusion that what the parties intended was the location of the river
and to preclude any change whatsoever, ever, for any reason.
Excuse me, Your Excellency?
The treaty itself specifically intended to preclude any change in the location of the boundary.
Yes, Your Excellency. Our submission was that the parties did want a stable boundary.
Where there is a background rule of customary law, can we infer that into the plain text, or does the text, if you like, have an obligation of making it?
Could you rephrase the question, Your Excellency?
Why should we infer that the parties meant to preclude the application of the ordinary customary law rule of avulsion versus accretion, unless they have so provided for in the text of the treaty?
Well, Your Excellency, because we would submit that although it was not expressed, by having recourse to supplementary means of interpretation, we can, such as the travaux preparatory of the treaty and the circumstances in which the treaty was concluded, we can see that the intention of the parties was, 1, not to lose the fertile delta area, and 2, Your Excellencies, in Merapi's contention, not to lose the ancient burial sites of its people. So the parties intend... Yes,
was this treaty developed at a time when we had an exclusive economic zone? Was it the intention of the parties to set a boundary relevant to the exclusive economic zone?
No, Your Excellency. The institution of the exclusive economic zone is posterior to the Treaty of Amity and Peace, which was signed in 1947. However, it is our contention that if the treaty, that first the parties both have claimed an exclusive economic zone, Furthermore, the applicant state has recognized the customary character of said institution, and we would not be enforcing a conventional rule in a treaty that only we have signed, but a customary rule which can be enforced on every nation. And therefore, Your Excellencies, if this court were to rule that the frontier remains where it has been for the last 53 years, the consequence would be that the Alma Shoals would lie in our exclusive economic zone, and therefore we would have the normal rights of a coastal state over an exclusive economic zone.
Doesn't the delimitation of the exclusive economic zone hinge upon the difference between your control of some coastline and the applicant's control of some coastline, which might shift with the shifting of the river?
Your Excellency, it is our submission that the land boundary, and the maritime boundary must be understood to shift together. If the court were to rule that the applicant state is right and that the frontier must move, then the maritime boundary should move with it, because if not, the consequence would be a dry coast.
Well, then it gets back to my first question. At the time of formation of your bilateral treaty, there was no concept of an exclusive economic zone. It wasn't within the contemplation of the parties.
No.
Why should the delimitation of the EEZ depend upon that treaty, that when the parties didn't even intend to have it control something called an exclusive economic zone?
Because the parties, Your Excellency, made reference to the maritime boundary. And although there was the institution had not been recognized, the institution of the EEZ, the maritime boundary the maritime boundary had been determined by the parties. And it is logical to think that and with the conduct of the parties afterwards, it did not claim that they had a right to fish because the exclusive economic zone belonged to them prior to the shifting of the river. So it is evident that both parties agree that the maritime boundary is determined by the land boundary. In the maritime boundary, we include the territorial sea, the exclusive economic zone, and the continental shelf being a part of the...
It's true that one would not want to leave landlocked coast, to have a coastline that belongs to you, but no territorial sea, so only way you can get out is at a perpendicular angle with innocent passage. Would be a kind of funny situation. Territorial seas and coastlines go together. But as Judge Paust says, there's no particular reason that the EEZ has to go together with that. Why can't we, for example, recognize that you might still have territorial sea based upon the old river boundary border, but that the EEZ nonetheless would change on a different gear, if you like?
Your Excellency, our submission is that the best solution found in international law is to have a single maritime delimitation line. This was recognized by the International Court of Justice the 16th of March of the year 2001 in the Qatar versus Bahrain case, in which the court delimited all the areas of the maritime boundary by using a single maritime delimitation line. It is our contention that the best solution under international...
Did the court say, though, that one was obliged to do that with a single...
No, Your Excellency, the court did not state that it was bound to draw a single maritime boundary. However, it is our contention that by doing so, that it has been its practice to do so on the grounds of the agreements between states, which could reflect state practice, and that it is the most logical consequence, Your Excellency, because as you pointed out, although the territorial sea could be deemed to the territorial sea could be deemed to go with the land, the fact that the exclusive economic zone just off the coast of the territorial sea would belong to another state would definitely cause a certain degree of problems. It is therefore our contention that the best solution under international law is to draw a single maritime line in order to distinguish. And, Your Excellencies, if this court were to rule that the exclusive economic zone that the exclusive economic zone of Merapi includes the Alma Shoals, the consequence would be that we would have the sovereign right to exploit the living and non-living resources of the area. And that sovereign right, Your Excellencies, in the particular case of Merapi, entails also the right to exclude Arabians from fishing the area.
From force, with military force? You mentioned before, I believe. It's your contention that you can use military force to exclude others from fishing in the area?
No, Your Excellency, it is our contention that we can seize and detain vessels for fishing.
I think that could be military force, but in any event, that's your contention. We have obviously, we have a boundary dispute between these two parties. Is it your contention that you can do that in view of Article 33 of the UN Charter?
Well, Your Excellency, yes. In this case, we are only enforcing our laws or our rights under international law. We're not contributing to make the dispute worse. The situation which was created, we made an announcement in August 1999 that any other foreign vessels, Arabian vessels, found fishing in the area would be seized. And still, Your Excellencies,
do you have any instances where this court in the past has recognized the right of a state to use seizure power, if you wish, to control its claimed sea areas?
Could you rephrase the question?
Are there any precedents that you would cite on behalf of a claim by a state to use seizure power or arrest power or military force to control a claimed sea area?
Not
To arrest vessels.
Excuse me, Your Excellency?
To arrest vessels or what?
I'm not aware of any case of this court yet.
Don't you have the power under the Law of the Sea Convention to enforce your own environmental laws in an exclusive economic zone?
Your Excellency, could you repeat the question?
As the coastal state, do you not have the power to enforce environmental regulations in your own exclusive economic zone?
Yes, Your Excellency, and we also have the right to enforce any regulation which relates to our sovereign right over the resources, and that is what has been done. We do not know, it is not clear from the compromise whether there is a Merapian law regarding the exclusive economic zone. However, it would be our submission that state practice shows that every time a state makes a claim to an exclusive economic zone, it usually does by the enactment of a law. And furthermore, that in any case, if there were no law, the fact that the Merapian government expressly stated that foreign fishing vessels, Arabian fishing vessels, found fishing in the Alma shoals would be seized and detained, complied with the essence, Your Excellencies, of that requisite of regulation, which is publicity. It would therefore be our contention that we had the right to seize and detain those vessels.
Do you rely on the fact that you are a developing country, a poor country, that does not have to share its catch?
Yes, Your Excellency. It would be our submission that under the institution of the exclusive economic zone, a coastal state which is developing does not have to share the surplus of allowable catch with the developed state which is seeking exploitation, but that the developed state should seek to exploit the area, the exclusive economic zone of another developed state. Those obligations, Your Excellencies, are mainly contained under Articles 62, 69, 70, and 71 of the United Nations.
You might have mentioned this at the start, but your neighbor never ratified that treaty. How is your competence enhanced by the treaty vis-a-vis a neighbor that has never ratified the treaty? Why do they have duties, relevant duties, under a treaty they've never ratified?
Your Excellency, because it is our contention that these provisions, as being part of the institution of the exclusive economic zone, have also acquired customary law status. And the customary law status of the EEZ was recognized, as we submitted, in the 1985 continental shelf case between Libya and Malta. It is also, Your Excellency, is also the applicant state has recognized the character of the exclusive economic zone, and they have actually claimed one. So it is our contention that we have the right, under customary international law, not under the UNCLOS, but under customary international law, to apply these rules which regulate the allowable catch and the non-obligation to share that surplus, if any, because there is no evidence, furthermore, in the compromise. We would like, Your Excellencies, to make a final submission with respect to the vessels.
With the permission of the President, if I just might follow up with one more question. Just a controversial question, but assuming it's not yet transmuted into customary law, let me ask you a question about the third-party effective treaties. It's a funny situation to have a treaty that engages most of the countries of the world that creates boundaries, and yet have a spoiler or an outlier who doesn't subscribe to that treaty regime. Are you relying upon any kind of argument that the treaty in some way is erga omnes, even as to nations that have not ratified it? Not because it's customary law, but because it's a special kind of treaty.
No, Your Excellency. We would not be making the argument that because it delimits the areas of the sea, this treaty has acquired, the rules pertaining to that matter have acquired an erga omnes character. We believe that every state, and it was decided by this court in the Anglo-Norwegian fisheries case between the United Kingdom and Norway, that a state can actually object to certain rules relating to maritime delimitation. So it would be our contention that a rule that can be opposed by a persistent objector cannot be erga omnes. Your Excellencies, with respect...
Yes, summarize.
Oh.
You have 5 minutes? Time? How much time do we have?
3 minutes.
Your Excellency, we would submit that notwithstanding the changing course of the principal arm of the river, we have the right to exclude Arabian fishermen from fishing the Alma shoals, notwithstanding said change because the frontier remains. Finally, with respect to the vessels, we would submit that that before the claim is heard by the tribunal, the parties, the alleged the fishermen who were deprived of their vessels have to exhaust the local remedies available in the courts of our own country. And in any case, that the seizure and detention was lawful in case the court rejects this preliminary objection of non-exhaustion of local remedies. Having submitted this, Your Excellencies, we would like to address briefly the issue of the deep seabed mining operation and its violation of the principle of common heritage of mankind. Your Excellencies, it is our contention that the seabed mining operation and any seabed mining activity is indeed governed by the principle of common heritage of mankind. And, Your Excellencies, the customary character of this principle has actually been recognized by our esteemed colleagues of the applicant state in fact.
Does common heritage mean the same as Article 136 of the 1982 Convention? Especially as you get down to 136, 137, you start talking about things that look like title in humankind. Is common heritage more diffuse, less than title, kind of an equal opportunity for exploitation?
No, Your Excellency. Our submission is that the essence of the common heritage of mankind principle is that mankind should benefit from whatever has been termed the common heritage, either outer space or the seabed, so it would be our contention that it does not imply that every state has an equal and unrestricted right over the resources.
Now, you've signed this new agreement in implementation of Part 11.
Yes, Your Excellency.
Isn't that an agreement that was instigated primarily by developed countries, as opposed to the interests of developing countries to have free access to those areas?
No, Your Excellency.
I think that's the view of the United States, for example, that such an agreement would obviate the Article 136, 137 regime.
No, Your Excellency, we beg to differ. Our submission is that the agreement for the implementation of Part 11 of the UNCLOS of 1994 actually provides for a more liberal regime, but that the essence of Part 11 is there still, and that is mankind should benefit. There should be sharing of revenues. It may not provide, Your Excellencies, for the sharing of technology, but in any case, we're not arguing that any state...
Why couldn't the applicant share revenues later? Why can't they engage in the development? They have access to that area, and they'll share revenues later.
Well, we would like to answer that question in 2 steps, Your Excellency. First, it was stipulated by the parties in the compromise that the resources extracted from the deep seabed mining operations would help build fire aircraft and short-range missiles. So it is our contention that there probably won't be any selling of the minerals, and therefore there would be no revenues. Secondly, Your Excellencies, it is our contention that states which were not parties to the UNCLOS and which later became parties, but at the time were not parties, created trust funds in order to comply with the obligation of sharing of revenues before the activity was performed. As an example, Your Excellencies, we would like to cite the cases of the United States of America, the most persistent objector to this common heritage principle. Second, the United Kingdom, France, Germany, Japan. Your Excellencies, all of those countries created these trust funds before they even performed any seabed mining. And there is no evidence, Your Excellency, that Erebus is indeed willing to share the revenues.
Although could we not order them to create a trust fund?
Yes, Your Excellency, you could enjoin Erebus to create a trust. And under that case scenario, Your Excellencies, we would submit that that we would accept the judgment, because that is precisely our claim. Our claim is we're not claiming that the ISA, an organization to which they are not members, is binding upon them. We're only claiming the essence, Your Excellencies. I see that my time is up.
I think the other team had some extra time, so if the President would permit another question. I thought the problem was that there was an imminent harm to the environment, not that this was a dispute over who's going to share revenue.
Your Excellencies.
What's happened to the claim about imminent harm to the environment?
Your Excellency, we have two reasons to oppose to that particular activity. The first one was addressed by me, which was the sharing of the revenues, the non-compliance with the common heritage of mankind principle. My co-agent shall be addressing in the course of his presentation the environmental harm that this activity could produce. But if Your Excellency wants me to elaborate on that particular issue, I would.
Well, it seems inconsistent for you to accept a regime allowing the applicant to continue mining as long as there's a sharing of revenue, and the claim that I assume your co-counsel will make very shortly, that there was this imminent threat to environmental harm. How do you balance those two claims?
That was my fault, Your Excellency. I apologize for not making myself clear. We have two reasons for opposing these operations. One regards the legal regime which governs the seabed. That would be satisfied, our concern would be satisfied by the sharing of the revenues. The second reason why we oppose this activity is because of the environmental impact that this could cause in the Grand Basin, and therefore in our specific interest to fish that area. That, Your Excellencies, would be addressed by my co-agent.
Insofar as common heritage is a customary law principle, or
yes,
common heritage includes both the economic and the environmental elements? The revenue sharing and the environmental question are both part of common heritage?
Well, Your Excellency, there are several regulations by the International Seabed Authority regarding, which is the organ which actually is entitled to exercise to apply the common heritage of mankind principle. And there are several regulations, for example, Your Excellency, the one enacted in July last year, which is the mining code, which seeks to prevent the damage that could be caused to the environment by this operation, but by this kind of activities. So it would be our contention that yes, the common heritage, by using the International Seabed Authority as its implementary organ, does provide for environmental principles to be carried out in every particular activity.
Before you go, can you just briefly tell us how has these principles transformed into customary international law and binding on the applicant?
Yes, Your
Very
Excellency.
briefly, please.
Yes, Your Excellency. We would submit that the sharing of the revenues comply with the two elements of state practice and opinio iuri, and having the burden of proof under the SS Lawsuits case of the Permanent Court of International Justice.
Do we have any opinion iuris and state practice in seabed mining?
Yes, Your Excellency. It would be our contention that not with respect to seabed mining as a whole, not with respect to every single obligation contained in Part 11, but with respect to the essence of the principle, we do. And we mean by the essence that mankind should benefit by receiving the share or sharing the revenues of the activities. And this, Your Excellencies, as was submitted, both the state practice and the opinio iuri can be evidenced by the creation of the funds by states that were not bound under a conventional obligation, but that actually practiced in creating these funds to comply with an obligation which they consider to be legally binding upon them, independently of them not being parties to the convention.
You know, there's a tax regime under the seabed authorities, Part 11. Does that, in your view, has come into customary international law, and therefore the applicant state will have to follow that tax regime?
Tax regime?
Tax regime.
A text regime?
Tax regime, yes, to pay taxation.
Taxation. No, Your Excellency, we would not submit that the applicant state is bound by the procedural obligations regarding the ISA, because not even by the taxation, Your Excellency, because we submit there is no state practice to it, although it would be very convenient that states abided by that, there is no state practice, and therefore there could be no rule of customary law. And under that premises, Your Excellencies, we will base our contention on that particular issue of the sharing of revenues, which has state practice, has opinion duty, and therefore could be binding under a treaty obligation as custom, outside a treaty obligation as custom.
All right, thank you very much.
Thank you, Your Excellency.
May it please this honorable court. Good afternoon, Your Excellencies. My name is Alejandro Franco, and as my co-agent already indicated, I will be addressing this court for the next 20 minutes regarding the following 3 issues. First, I will be arguing that the Arabian seabed mining operations are in breach of international environmental law. Second, that MENAPI is not responsible under international law for the attack against the Arabian seabed mining facility. And third, that MENAPI is not under an obligation to extradite those members of the Aqua Protectors responsible for the attack to Ereus for prosecution. May I be permitted to proceed?
Yes, please.
We've heard that you're supporting terrorist operations. How do you respond to this word terrorism?
Your Excellencies, in that particular regard, we would like to bring forth to the court the fact that our esteemed colleagues of the applicant state, when defining terrorism, we submit have not issued the 3 key elements that indeed have been reiterated by the international community as being the key elements in order to define what a terrorist action is. Your Excellencies, what we submit is that these elements are the use of violence, the intent to cause fear, and the achievement of a political objective. Your Excellencies,
wasn't there a political objective of the private group in this instance?
Your Excellency, we are not in any way contesting the political element. What we are stating is that the intent to cause fear cannot be found in the present attack. Your Excellencies, the clear intent of this attack was to disable a seabed mining facility.
What does it matter whether it's terrorism or not? It's clearly a use of force, is it not?
Your Excellencies, we would submit that the only way that this could be stipulated to be a use of force would be with regards to the Kingdom of MENAPI. And Your Excellencies, what we submit is that the Kingdom of MENAPI is not responsible for the attack on the seabed mining facility, which was undertaken by the non-governmental organization of the Aqua Protectors. Your Excellencies, what we submit is that in the present case, the attack cannot be imputed to the Kingdom of MENAPI. In fact, as has been ascertained by this court in the Nicaragua case, the financing of an operation by a state does not provide sufficient evidence to impute the actions of individuals to a state. Your Excellencies, we would like to bring forth the fact that our esteemed colleagues of the applicant state have submitted that under the principles set forth in the Corfu Channel case, the Kingdom of MENAPI can be found responsible for the attack. Your Excellencies, we would like to distinguish the Corfu Channel case from the case at hand. Your Excellencies, in the Corfu Channel case, the principle that was established is that a state cannot knowingly allow the use of its territory for acts contrary to another state.
Wasn't there another principle? I think Albania and the UK were found to have violated international law. Didn't the UK violate international law by engaging in self-help efforts to police the area, to police out the mines from the area?
Your Excellency, we would submit that in that particular case, the navigation of the strait was found, of the particular strait, was found to be by the United Kingdom to not be an illegal activity. However, with regards to Albania and the placing of the mine, what we would submit is that indeed there was found that under the principle of under a sicutere principle, a state is responsible. But Your Excellencies, what we submit is that that is not what is occurring in the case at hand. That this attack took place outside the borders of national jurisdiction in the high seas, and that according to this,
you're saying you were not aware that it was about to occur when you financed this environmentalist group?
Your Excellency, I'm sorry if I have not made myself clear. What we are submitting is that under this principle, the fact that there was a financing, as was found in the Nicaragua case, does not impute the actions to the.
No, I agree. Albania, though, was found to have been liable for not warning other vessels in the area of something they knew about as a danger. Did you not know that this danger was about to occur
I understand your
no matter where it occurred from.
I understand your concern, Your Excellency. What we would submit in that particular regard is that we do not contest that there was an advance warning as shown in the compromis. However, Your Excellency, what we submit is that, again, if we distinguish the Corfu Channel case from the case at hand with regards to the amount of warning that was needed, in the Corfu Channel case, there were monitoring systems that Albania utilized with regards to the mines, which in fact was a strict test to show that Albania knew of these mines. And Your Excellencies, what we submit is that in the present case, and as was also ascertained in the Corfu Channel case, when there is room for reasonable doubt with regards to the evidence that can be found, these elements cannot be utilized, Your Excellencies, if there is such room for reasonable doubt.
But what about the Honduran death squad case of the Inter-American Court of Human Rights? The failure to repress a violent activity can itself be attributed to the state, no?
Yeah, well, yes, Your Excellency. However, we would submit that in the present case, there cannot be said that the Kingdom of Merapi had the ability to repress the activities undertaken by the Aqua Protectors.
But you financed this organization.
Right.
One of the provisions cited by the applicants involved, I believe, Article 2, Paragraph 7 of the Charter, the non-intervention norm, that you cannot foment, finance, tolerate subversive or terrorist activities from your shores to injure other countries, for example.
Your Excellency, in that regard, what we would submit is the fact that with regards to the non-intervention, as was established in the Nicaragua case, the intervention that was seen was because there were more than sufficient links with regards to the equipping, financing, supplying, organizing, and training, and that in the present case, Your Excellencies, there are not sufficient elements to indicate that there is intervention by the Kingdom of Merapi with regards to the Republic of Ereus.
What I'm wondering, though, is two things. One is that in Nicaragua, these were attacks that were launched. It was a question of American responsibility for attacks launched by the Contras. And these were attacks launched from non-North American territories. Whereas here, the attack is being launched from your very own territory.
Your Excellency, we would submit that it would be speculation to state that the attack was launched from the territory of the Kingdom of Merapi. All that we are provided for in the compromis is that the non-governmental organization was headquartered in the Kingdom of Merapi. Nowhere can it be stated that the attack was launched from the Kingdom of Merapi. All we know, Your Excellencies, is that the non-governmental organization...
Your nationals, did it not?
Yes, Your Excellency. The offenders that are being asked for some of them are nationals of the Kingdom of Merapi.
If you look at the command responsibility, I realize that war crimes are a specialty that not all of us care to engage in, but if you look at the recent jurisprudence of the International Criminal Tribunal for the former Yugoslavia, they seem to suggest that knowledge plus a duty to prevent is sufficient for liability. You had knowledge. It was your nationals. Is there no duty to prevent on the part of a government in controlling the activity of its own nationals?
Your Excellencies, what we submit is that with regards to the knowledge, it cannot be clearly indicated how much knowledge, how much previous knowledge there was from the Kingdom of Merapi to the attack. However, Your Excellencies, the principle of, if I'm not mistaken, of due diligence, Your Excellencies, with regards to the attack, again, we would submit that the fact that it is not clear how much advanced knowledge there was.
But assume there was knowledge. Was there a duty to prevent?
Your Excellencies, we would submit that no, that there was not, that in this particular case, in the case at hand, it cannot be stated that there is a duty from the Kingdom of Merapi to have prevented this attack, which, Your Excellencies, with regards to the essence of the attack, that our esteemed colleagues of the applicant state are stating that it is a terrorist attack, we would submit that it is not. And Your Excellencies, we believe that the importance of this submission is the fact that our esteemed colleagues are utilizing the Convention on Terrorist Bombing. And Your Excellencies, this first of all, neither Ereus nor the Kingdom of Merapi are the parties to this convention. And second of all, Your Excellencies, the attack cannot be deemed to be an act of terrorism.
I am troubled, though, by the inconsistency in the position in your submission, which is that on the one hand you say you didn't know, you didn't do it, and on the other hand you say if you did know and if you did do it, it's self-defense. Don't you have to choose one point of view or the other?
Your Excellency, our primary argument is that we are not, the attack cannot be imputed to the Kingdom of Merapi and that we are not responsible for the attack. Your Excellency, even though in the note it appeared that it was believed that the attack was justified under Article 51, this in no way, Your Excellencies, precludes us from making it our primary argument that in the same note we indicated that we did not plan or participate in this private action, and that it is our primary argument, Your Excellencies, before this court today, that we are not responsible for the attack and that the attack cannot be imputed.
You're arguing that.
Let's move on. Is there any provisions in the ILC's draft articles on state responsibility can be utilized to support what you just said?
Yes, Your Excellency, what we submit is that the draft articles on state responsibility indicate that actions of private individuals are imputed to the individuals themselves. And, Your Excellency, I do understand this court's concern with regards to Article 8 of the draft articles, in which it states individuals acting on behalf of a state, those actions can be imputed to the state. However, Your Excellencies, what we submit is that in the present case, because of the fact that the only links that can be seen with the attack would be the financing, which again, in the Nicaragua case, was found not to be sufficient to impute actions of individuals to a state, that Your Excellencies, it would be clear that the attack cannot...
There were some other facts brought out. I think one of your officials in some newspaper publications, I'm not terribly clear on this, admitted or recognized that this was going on. Is that true? Or could you clarify this for us?
Your Excellency, what we submit is, if Your Excellency is referring to the fact that the diplomatic note which said that the action was a justified action, or the paragraph 18, which Your Excellency indicates that the Merapi Times indicated that.
Yes. Yeah.
Your Excellency, we are not contesting in any way whatsoever that that there was oversight hearings of the legislative body of the Kingdom of Merapi did reiterate that reports that stated that there was funding and a warning of the attack are not true. What we are contesting, Your Excellency, is that with regards to at the very least one of the other elements that has been tried to be utilized to impute the actions, as can be seen in the written memoirs of our esteemed colleagues, is one of subsequent approval, Your Excellencies. What we like to bring forth to the court is that this principle was utilized previously in the Hostages case, Your Excellencies, but that, however, when we distinguish that case from the case at hand, it is clear that there exists no such degree of subsequent approval in order to impute those actions to the Kingdom of Merapi.
Failure to either prosecute or extradite is considered approval, at least again in military command responsibility. You have said there's no duty on the part of Merapi to extradite these two, or these several gentle people to Erebus. But if we conclude that this was state-sponsored, isn't there an exception to the ordinary customary law rule that there's no duty of extradition? That is, even if there is no customary law rule of extradition in an ordinary case, in the case of state-sponsored terrorism, one can't presume the state itself would try its own acts. Isn't that the principle of the Lockerbie case in the Security Council, that is an extraordinary duty?
Your Excellency, with regards to the Lockerbie case, we would first, I would like to answer your question in two parts. First of all, with regards to the Lockerbie case, there is a clear difference with the case at hand in that in the Lockerbie case, there was the 1971 Montreal Convention on the suppression of unlawful acts against the safety of civil aviation, which indeed included for the audere adjudicare principle, Your Excellencies, which is the principle of a state must either extradite or prosecute. in the present case, Your Excellencies, there is no extradition treaty between the parties. However, Your Excellencies, we do understand that, as has in fact been submitted by authors such as Sheriff Mbasuni and Edward Weiss, with regards to terrorism, it can be stated that there can be an obligation to extradite individuals. However,
What's the nature of this duty, aut datere aut judicare, as a matter of customary, if it's a matter of customary international law? What is your exact obligation?
Your Excellency, the exact obligation is that the individuals, that the state has the option to either prosecute the individuals or extradite them.
And you're not extraditing them? And you're not prosecuting them?
Your Excellency, no. What we are submitting is, I'm sorry if I have not made myself clear, is that the aut datere aut judicare principle with regards to common crimes is not a principle of customary international law, which is the only way that
the Bassioni book says that it is.
Your Excellency, the book by Bassioni states that it could be stated to be under an international crime such as terrorism. First of all, we submit that this is not terrorism, and second of all, Your Excellencies, even though the Sheriff Mbasuni states this, there is no state practice, Your Excellencies, which is one of the key elements.
Didn't Hugo Grotius take the same position some time ago?
Pardon me, Your Excellency?
Didn't Grotius take the same position some time ago, that even for common crimes like murder, because murder is heinous, that there's a duty on the part of states to extradite?
Your Excellency, again, we would submit that even though authors, which under Article 38 are subsidiary means for the determinations of the rules of law, have stated these principles, these ideas, what we would submit is that the only way that this principle could have reached customary status is not if authors have stated this, but if there is state practice and opinio juris. And Your Excellencies, with regards to the aut datere aut judicare principle, there is no state practice outside a conventional obligation that a state feels that it has.
Except Lockerbie, in which the Security Council itself, which is obliged to act lawfully, imposes upon Libya a duty that goes beyond the Montreal Convention, that forbids Libya from trying the defendants themselves and demands they be extradited. So we have Grotius, who I have trouble considering just an author, together with the state practice of Lockerbie.
Your Excellency, pardon me for having said just an author. What we meant are the renowned authorities on the particular issues. However, Your Excellency, with regards to the Lockerbie case, we would again like to distinguish that case from the case at hand and the case that is before the court presently, and is the fact that the attack in the Lockerbie case was indeed, there was a convention, and indeed it provided for that specific attack, which was an act of terrorism. And Your Excellencies,
Sorry, finish that.
And Your Excellencies, in the present case, we deem that the attack is not an act of terrorism, and that there is no convention that provides for such an act, and that there is no extradition treaty between the parties.
So what are you going to do with the perpetrators?
Your Excellencies,
Are you going to prosecute them?
we submit that, as in fact was occurred in the Lockerbie case, we would bring forth to the court the fact that it would be possible to surrender these individuals to a neutral third party, Your Excellencies, which we would not contest in any way whatsoever. The reason, Your Excellencies, that the Kingdom of Menapi feels that it should not extradite these individuals.
Now, Libya got in trouble, according to some, because it was not living up to its obligation under that treaty to either initiate, it's an alternative duty, by the way, either to initiate prosecution or extradite. Are you asking now for a new political agreement? I guess you're asking us to sanctify that, or should we rule on whether or not you're living up to your obligation, aut datere aut judicare, if we find that it's customary?
Your Excellency, if this court were to find that the rule is customary, and then, Your Excellencies, what we would submit is that with regards to the prosecution of the individuals, in fact, the attack of these individuals took place in September, Your Excellencies, and only 2 months have gone by during the course of that this case was brought before this court. And what we would submit is that, Your Excellencies, whatever this court were to decide, Your Excellencies, the Kingdom of Merapi would prosecute the individuals if this court were to decide that.
On what crimes?
Your Excellency,
You can answer my question first.
For the crimes of destruction of property and homicide, Your Excellencies.
I see. According to your national law.
Yes, Your Excellency. Thank you very much, Your Excellencies.
Your Excellencies, the question before this court really is whether states can fund individuals to bomb and destroy the property of other states and as a result kill the citizens of those states in response to the existence of a dispute between the two states. Your Excellencies, Agent for Merapi has sought to justify his position on the grounds that this is not imputable to the state of Merapi, repeatedly citing the Nicaragua case in support. Your Excellencies, this was never the contention of Erebus in the first place. They are responding to an argument which, by page 1 of our written submissions, we made very clear we were not making. Your Excellencies, they go on to concede that the International Seabed Authority is not binding on Erebus and do not establish how, therefore, Erebus could be in breach of its environmental...
How do they agree that the ISBA is not binding on them?
Your Excellency, this was conceded by the first agent for Merapi when she said that the International Seabed Authority regulations are not binding on Erebus.
Are you?
They were customary, though, I thought she said.
No, Your Excellency, she did not say so. Yes,
Common
Your Excellency.
heritage was.
Are you claiming that the common heritage of mankind has no environmental component?
Certainly not, Your Excellency. If I may demonstrate how Merapi's position is inconsistent here, they claim that Erebus is in violation of its obligations because of its breach of the common heritage principle by not sharing. This is inconsistent with the relief which they have sought in paragraph 22b of the compromise, which merely states that they want the facility either relocated or upgraded. Your Excellencies, they don't care about the sharing. They just want the thing moved. So therefore, Your Excellencies, this appears inconsistent. Furthermore, in terms...
Regardless, common heritage should have two components. One is distributional justice, sharing with poor countries. You're a very rich country. And secondly, it is to avoid environmental degradation, which the Security Council in 1992, in the Statement of Heads of State, found could be a threat to peace and security.
Yes, Your Excellency. That was the other foundation of their case, which they never managed to make. In this respect, Your Excellency, Erebus's position is that we have complied with our environmental obligations, which were stated as customary, Your Excellency, in, for example, the Nuclear Weapons Advisory, paragraph 29. In this case, Your Excellency, we have complied even with the precautionary principle, assuming it is customary law. For example, we have submitted this matter to our competent national authorities, taken... Yes, Your Excellency.
Yes, you have said very little about the legality of your mining outside the Law of the Sea Conventions. Are you aware, subsequent to the agreement on Part 11, all the states concerned actually sat down and have agreed on the mine sites? So most likely, the mine site that you're going to operate actually is on one of the mine sites of one of the states. So if that, maybe, could that be considered as, therefore, your operation is illegal, and therefore would cast a different light on the whole situation?
Your Excellency, I see that
my you may answer.
If I may just answer Your Excellency's question and summarize. Yes, Your Excellency. With regard to the mine site being claimed by other states, it is our position that this cannot be possible on the facts of the compromise because the Grand Basin area still consists of commercially abundant stocks of cod, haddock, and halibut, which the United Nations Fisheries and Agricultural Organization has recognized are no longer commercially abundant, even, for example, in the Clarion-Clipperton zone of the Pacific. Furthermore, Your Excellencies, if unilateral mining is indeed a grounds for relief sought to be imputed by Merapi in this case, it is also inconsistent with the same relief which they have sought, which is that they are not asking us to stop either, Your Excellencies, nor are they asking that our claim not be recognized under Part 11. They are merely saying upgrade or relocate. Finally, Your Excellency.
Yeah, but you have not given what is the legal basis for your seabed mining. Yes. What's the legal basis in international law?
Your Excellency, the legal basis for this we would submit is that states are allowed to mine the deep seabed if, for example, they are not parties to 1982, under, for example, the analogous position of the United States, that this is a reasonable use of the high seas under the obligations under 1958 Geneva High Seas
Any
Convention.
authority?
Your Excellency, this is the position consistently taken by the United States until, for example, it had signed the proposal.
But you are not United States.
No, Your Excellency, we are not the United
And that
States.
doesn't make it right, does it, sir?
I beg your pardon, Your Excellency.
The fact that the Americans have declared a position to be international law doesn't necessarily determine the case.
Yes, Your Excellency, we recognize that one state indeed cannot do so unilaterally in that case. Your Excellency, our position merely is that we did, our primary position is that we had a right to do so, but even if this point, Your Excellency, is in dispute based on the 1958 Geneva Convention, nevertheless, it is not an issue before the court because Merapi has not sought to argue it as a grounds for why we are in breach of our obligations. And therefore, we ask that this court declare that states cannot fund individuals to bomb the property of other states simply because of the existence of a dispute, and then claim at the end of the day that they have complied with international law by doing so. Your Excellency.
Just one moment on President Lee's question, if I may, though. It's one thing to say that a persistent objector can stand outside a customary regime, or that a third-party state doesn't have to join a treaty when it's engaged in self-regarding activity. You don't have to necessarily join every human rights treaty. But here you have competitive claims to the same seabed bottom, and the overwhelming majority of countries in the world have taken this to be a mine site allocated according to the principles of the Seabed Authority. So you're just entitled to swoop in from outer space and claim it to be your own because you've chosen not to join the treaty regime. Isn't there something wrong with that?
Not at all, Your Excellency. Erebus's position is that because we have complied with our obligations to protect the marine environment, to have due regard to the interests of other states, and because there's no evidence on the compromise that this area, which we have sought here, is indeed claimed by any other area. In fact, I do not believe any of the 7 pioneer investors have claimed this so-called Grand Basin area or its nearby area, Your Excellency. So therefore, our position is, if a contradictory claim did come, I'm afraid I have no instructions from my government on how to deal with the matter. But as it stands, Your Excellency, that is Erebus's position on the common heritage point.
Do I understand you actually are arguing that the 1958 Convention and the 82 Convention coexist side by side at this very moment?
Your Excellency, because we are not a party to the 1982 Convention, and unless Your Excellencies find it to be a customary obligation that we must join the Convention binding on Erebus, our position is that our obligations with regard to our activities in the high seas are still governed by the 1958 High Seas Geneva
So if we rule that way, you will accept it?
Your Excellency, we will accept any decision of this court. Your Excellencies, unless you have any further questions for me, this rests the case for Erebus.
Thank you.
Thank you, Your Excellency.
Your Excellencies, the Kingdom of Menapi will now exercise its right to serve rebuttal. And, Your Excellencies, we have not submitted that Erebus is not bound by the regulations of the ISA of the environment, because we believe, Your Excellencies, that the environment as such is regulated by general principles which in themselves have been violated so far. For example, Your Excellencies, the general principle contained in Article 21 and Article 2 of the Rio and Stockholm Declaration, Your Excellencies, which have been recognized by this international tribunal as the applicant state submitted to have acquired customary law status, mandates that states ensure that activities within their jurisdiction or control do not cause damage to the areas beyond the limits of national jurisdiction. And Your Excellencies, has Erebus ensured that its activities will not cause damage? We submit that it has not. And it has not, Your Excellencies, because although it has submitted the reports of its own government and its own university, there are several other studies around the world which indicate that there might be damage. And we submit, Your Excellencies, that in the present case, we must take a precautionary approach with respect to the seabed mining activity and with respect to the environment as a whole. Your Excellencies.
Are you now allowing them to continue to engage in seabed mining in that area?
No, Your Excellency. We are submitting this with respect to the environment. With respect to the environment, the activity is illegal per se. Now, with respect to the common heritage of mankind principle, Your Excellencies, we have sought a declaration from this court a declaration that the operation is unlawful under international law. And that in itself includes the fact that the common heritage of mankind is being violated. We seek that the court declare the illegality of the activity, and that therefore EREUS should conduct the operation in accordance with the principles of common heritage.
I take it your first argument really is almost that even if the Republic of Erebus has a right as a treaty rebel, a treaty outlier, to engage in its own deep seabed mining, that to damage the fish stocks is almost the equivalent of transboundary pollution. They can't claim to own the fish stocks on the high seas.
Your Excellency, you're referring to the argument I just made?
Yes.
We're submitting, Your Excellencies, that even under, even if the activity if the activity causes a harm, the consequence will be that it would be breach international law. But there would be another consequence, Your Excellencies.
Doesn't all mining cause some harm? There's very little completely 100% pure mining.
Yes, Your Excellency. However, this particular operation has, and we understand that there is a certain degree, not a grave damage that is permitted under international law. But this activity, by the evidence of the compromise, seems to be causing a great controversy on the international. Your Excellency, I see that my time is up. This activity in particular is causing a grave controversy in the international plane. The International Seabed Authority has pronounced itself with respect to the activity. The Security Council has actually issued a statement with respect to the activity. And scientists around the world have also opposed the operation. So we can very well presume that the danger to the marine life is actually a grave danger. And as a grave danger...
Does the ISBA have authority over this matter? Because the applicant has not ratified any other treaty relevant at the 1958 conventions.
Your Excellency, although an argument could be made that the International Seabed Authority should be binding upon non-parties, it is not an argument that we are making before the court because of the controversial character of said argument. It would be our contention that this same tribunal could decide upon this activity should or should not be conducted. What we are seeking here is to protect the environment, and we have seen several cases of destruction of the environment in the last two decades, and it is our contention that no activity, however good, should be conducted, because even if it is good, it is optional. While protection for the environment, Your Excellencies, is not optional but mandatory.
Why? Is it part of international law?
It is our contention that yes, Your Excellency, the protection to protect and respect the environment has acquired customary law status. The general
What evidence
provision,
do you have of this duty to protect the environment?
Your Excellency,
as custom?
Yes, Your Excellency, it was recognized by the International Court of Justice, this general obligation of state responsibility with respect to the environment in the case concerning the use and threat of nuclear weapons in 1996, as well as in the Chico Los Neguemaros case, it was reiterated by this honorable tribunal. So it would be our contention that there is indeed a general obligation to protect the environment, and that if this activity breaches the environment, even in the case of sharing the benefits, Your Excellencies, then both, if in the case that it is conducted as it is.
There's no rule of reason. I don't mean to sound like a Republican, but there's no rule of reason. If the mining would yield $4 trillion and feed all the world's poor, you still couldn't do it because the fish will suffer.
No, Your Excellency. If it would, if you balance the good of the operation and the bad elements of the operation, and human rights are satisfied because of the fact that there will all the population of the world would be fed by that particular operation. We're talking of a totally different scenario than the one presented here today. But it is our contention that in the present case, in the case of an operation that will only that could be conducted under other standards, that could be upgraded, then what this court should rule is that the operation should be upgraded, and not that it should go ahead with the absolute disregard of basic principles.
What if we can find to force the applicant to upgrade using the best technology to avoid all environmental harm? You would agree that the operation could go ahead. There's no other legal rules that would prohibit the applicant to go ahead.
The sharing of the revenues, Your Excellency, however...
Provided, yes, you have the sharing of revenues.
Yeah,
they agree to pay, for example, $4 billion and there's no environmental harm, can they go ahead? Are there any rules in international law still prohibit them to go ahead?
It would be our submission that under that case scenario, the applicant state could go ahead, Your Excellency, with its operation because it would be compliant with the essence of the common heritage of mankind and with its environmental principles.
Thank you.
Thank you very much.
Can we return? We have to retire. If you gather your things. So shall we begin to celebrate, or the celebration's over? Well, are you ready? Yeah. Good. We go first, the best oralist. Mr. Chang, Tai Hui, Jason. Runner-up oralist. Do you have anything for her? No?
I can give her some flowers.
Okay. While you were celebrating, we were debating, so we have come to the conclusion we also have a runner-up oralist. Señorita Ruisa Repavance. Now, the runner-up of the two teams, team number 743. One minute. One minute, 1 minute. I have not yet announced the winner. It's a simple deduction, isn't it? Team 691.